Everyone would please take their seats. We will call the November meeting of the County Clerk's Office Modernization Task Force to order at this time. Madam Secretary, please call the roll. If you are participating virtually, please let us know whether you are participating from your district or from your annex office.
Senator Mills.
I'm here in my district.
Senator Webb. Senator Wheeler. Representative Bridges. Representative Flannery.
Present in the room.
Representative Tackett Lafferty.
Present from the 95th District.
Senator Howell. Co-Chair Meredith.
Present in the room. Do have a quorum and are duly constituted to do business. At this time, we need a motion to approve the minutes. We don't have minutes, do we?
Yeah.
I didn't see them. Motion to approve the minutes from the October meeting. I got a motion from Representative Bridges, a second from Representative Flannery. All those in favor say aye. Aye. Any opposed? The ayes have it. Should have a little more relaxed agenda today, but we are going to get started at this point, and I am going to ask Ms. Jennifer Hayes from A&R staff to be our first presenter for the day, and she's going to talk to us about the history of the legal process tax that we have discussed previously in this task force.
Mr. Chairman, this is Senator Wheeler. I'm sorry I'm a little bit late. If I could be recognized in the district.
Thank you, Senator.
Thank you, Mr. Chairman.
Okay, I think my slides are up and everybody can see those. I'm just going to briefly talk about this miscellaneous tax. And when I say legal process tax, most people go, what? You know, I didn't even know there was such a thing. But where we are today, where we've been in the past, and just some statistics about that tax. So, So up arrow or down arrow? Which one? I've done both. The what? This button? Okay. Click, okay.
And down here it has the arrows.
Okay, all right. Thank you. Okay, so where we are today is KRS 141010 imposes the tax, and it's for any person filing certain documents with the county clerk's office. You can see here the list is there are 5 different documents or processes that are currently taxed, and the tax is either $4 or $4.50 for a marriage license. So you can see that the list there is pretty short, pretty self-explanatory. The county clerk's required within 10 days after receiving those taxes to remit that to the Department of Revenue. And then once the Department of Revenue receives that, $1 is deposited into the Department for Library and Archives account to be used for preserving and retaining public records. And the remaining $3 or $3.50 is deposited into the general fund. We've tracked the current statute as it is today all the way back to 1936. So since that time, it's been pretty much in this same format of assessing a tax on specific actions or processes. And you can see back in 1936, the list was much longer. The taxes were very varied across the documents and at a much lower rate, as low as 2 cents for each 20 words in a writing of certain documents. So won't go through the list, but there's the list for your information. And I just point to that longer list and the lower taxes as a sound tax policy provision for sound tax policy, the base needs to be broad, which then allows you to have that lower rate. And over time, the legal process tax, the base has been narrowed and the rate has increased. So if I go back to that list that I just showed you, you'll see that in 1936, there were processes that were taxed that really weren't related to the county clerk's office. It may have been related to the circuit court clerk. And there may be other documents elsewhere, in the county at that point in time that were taxed. So taxes were coming from multiple sources related to the legal process tax. We can track legal processes. They're listed here as fees, legal, all the way back to 1800. So in 1800, receipts to the Commonwealth, 70% of those receipts were property tax. 30% of the receipts to the Commonwealth were in these legal fees that are assessed, the legal process tax. You can see over time, 1850, not much change, but we have the introduction of licenses as receipts to the Commonwealth. When we get to 1900, you see a little more receipts coming to the Commonwealth in the form of federal funds, a small sliver there. And you begin to see over time that the percentage that is contributed to the general fund from legal fees starts reducing. We were originally at 30%, dropped down to 29%, then to 21%. But by the time we get to 1950, that is only 7% of the receipts coming to the Commonwealth. And you can see during that time, between 1900 and 1950, we have the introduction of sales and gross receipts tax, income taxes, inheritance taxes, and other taxes that are being imposed. And then finally, when we get to 2000, you can see that the sliver is very small, and then it falls completely off the pie chart when you go past 2000. This chart depicts the legal process tax receipts for the past 10 years, and you can see they're relatively stable. You do see a little bit of a dip in 2020. I think that might compare most closely with 2011. But I think you've heard testimony because of the pandemic, and court actions weren't, courthouse offices weren't open. That's probably the reason for that dip. And then I think the surge in 2021 is that pent-up demand then being released. Courthouses seem to be opening up more, and so those actions are then taking place. So I would anticipate that would level back off after 2021 and be more in line with the previous years. And then this last bar graph is a depiction of the year-end balance for the Local Records Grant Program. This is the $1 that is peeled off and is deposited into the account for libraries and archives. And once again, pretty level with 17, 18, 19 years being some leading years. You see 2020 is down, and then 2021, that big bar graph in that year in balance. And I think you heard earlier testimony in this task force about during the pandemic, projects were not being let, and so that's the reason for the large end-of-year balance. So that is just a real quick, brief overview of legal process tax, and I'm here to answer questions or help in any other way I can.
Any questions from members of the panel? I do have one really brief one, Jennifer. With regard to the fees, we know now that all of those are collected by county clerks currently. Mm-hmm. Do we know when the last of the fees that were collected by any other entity would have been repealed, and since when we have been solely relying on the county clerks to collect that tax?
I would have to go back and look through that to, if you really want to know a date, I can get that to you.
I apologize for not asking you about that ahead of time, but if you could get that to us, it would be appreciated.
We'll do it.
Any other questions? Seeing none, thank you very much, Jennifer.
Thank you.
We are now going to move on to our second presenter, the folks from DRMS. If you all would come to the table, introduce yourselves for the record, and then you may proceed with your presentation.
Good afternoon. Thank you so much for having us here today. Really appreciate the time to come in and speak with all of you. We are Data Records Management Services. We're from our corporate offices in Paducah, Kentucky. To the left of me is Joe Wiseman, our Chief Technical Officer. And to the right of me is Michael Malakot, who's also our Information Systems Specialist. He's replacing Otis today, who unfortunately couldn't come in. So as we begin our slide, the information contained within the slideshow is pretty straightforward. But we serve approximately 30 counties, county clerks across the state. We also serve a number of PVA offices, sheriff, county attorneys as well, with collectively about 45 county offices. We continue to grow across the state because we're very proactive in what we see and things, how the environment is changing. And so we try to adapt to that and try to make it more applicable in connection with the county clerks and their offices and the things that we see that are being challenged there. So part of our suite of products that we serve is through our name says it all, really. It's Data Records Management Services. It's information and how it's handled. And that's what land records is how we handle the information there. And we also do that in conjunction with our partners, CSC, EPN, and Simple File for electronic filings of land records. We also provide tax collection software for the multiple offices, marriage records, title liens, and accounting programs. We also offer digitization services, microfilm and data conversion services, online record services, online payment options as well. Currently, in the state, we are the only CGIS company that has achieved compliancy. And what's important to note about that is in 2020, roughly between October and December, the DOJ, the FBI, and the KSP launched an investigation into an audit of various vendors across the state who handled secured information. And at the end of that, we were informed that we were the only vendors that were able to achieve the CGIS compliancy. And so we immediately went into CGIS training, and all of our employees are now CGIS certified. But part of that is it lends to a unique perspective into how we engage in the business of the county clerks. Because the same framework that we use for CGIS compliancy is also the same framework that is used with the county clerk's offices. And some of those techniques that we use are both a variety of hardware devices as well as software devices that not only manage the services within the county clerk's offices, but offer real-time protection. It's not a firewall, and it's not a device that actually sits there and waits for an update on Mondays just like Microsoft does. These devices are actually on real time. It can happen anytime during the night. When you and I are sleeping, these systems are wide awake and they're constantly being updated. Some of the information that they protect us from is, of course, the antivirus, the applications, visibility, URL filtering, email security, anti-bot, anti-spam, and the list goes on and on and on. As being recognized as one of the vendors in Kentucky with CGIS compliancy, it kind of affords us a unique perspective in how we design the networks and the security and the prevention of cybercrime. Our networks utilize next-generation devices that are designed to preemptively stay one step ahead of the criminal-minded. With the rise in cybercrime, I guess we've all pretty much have heard about the ransomware by now. And unfortunately, our clerks are not, what's the word I'm looking for, absolved from those attacks themselves. But ransomware last year attributed to $416 million across the country that was actually paid out. According to Forbes, we're up to $580 million as of October this year. So it's on the rise. And to give you an example of how pervasive it is, last week at the County Clerks Conference, Homeland offered a workshop on cybersecurity and infrastructure security. And one of the things they suggested was pretty standardized policies that should be implemented in the county clerk's offices. But this is where the problem lies. Most county clerks do not use their own IT security people. They rely on vendors such as ourselves to implement these specific changes to protect and to make sure that these devices are in place so that the county clerks are not at risk and the integrity of their records are protected. And unfortunately, most of them are not really adhering to policies like this, and I'm saddened to say. So as you know, luckily for us, when they brought this to our attention last week, it was interesting enough because we've been doing it for over 5 years, and I think that's what's kind of given us the CGIS compliancy. It's as we go through our security that we offer to the clerks, it's the same security built on the same framework as we do for high-level security information that we use for police departments and other high-level risk companies that we work with. Our data replication is rather unique in itself. Most companies have said that they've replicated their data offsite, but one of the things when you look a little closer, what's being replicated is basically just offloading what's in the county clerk server, but what's not happening is a synchronization process that updates it every 5 minutes like ours. So if there's a correction made to a record, the correction is actually corrected within 5 minutes back in the cloud space. That in itself is unique. The data storage is actually stored on 4 different multiple geographic locations across the nation, utilizing a 128 or 256-bit encryption. It allows for the security of the data to maintain its integrity. One of the other things I want to point out is that we do not hire foreign nationals. Foreign nationals are often used in processing documents at the county clerk's offices, not by the county clerks themselves. Foreign nationals are used through third-party vendors, and that information is sent overseas after it's scanned, and it's processed in countries like India, Colombia, countries that really don't even have a good relationship with the United States government. They're brought back in an FTP secure folder, then processed into the county clerk's office. The problem with that is when we have other vendors that are then given a grant or given the opportunity to scan these records and they take them overseas, a couple of things are happening here. One of them is, of course, it's price driven. Overseas, third world countries, you earn roughly $2 to $3 a day according to the U.S. World Bank. So the competition, of course, is slighted to go that direction, especially when they're constantly being told that the prices are just not justifiable. So in essence, they're taking that information, sending it overseas, but the real critical part of it is what comes back. That is the question, because embedded in this information can be a slew of misinformation, because we're not talking about 10 records, we're not talking about 100 records, we're talking about thousands of records, hundreds of thousands of records that are being sent overseas without any parameters as to what can be sent and what can be brought back. So in essence, it promotes the liability in the county clerk's office without them even understanding what's happening behind closed doors. Nobody's ever bringing the subject up, so it's something that maybe we should consider when we look at security policies within the framework of the county clerk's offices and other offices, really, across the state. Additionally, we also use only E-Verify employees for all of our 21 employees at DRMS. We also are vetted with the CGIS. Yeah, you have to go through a vetting part. where they do a bunch of background checks, they photograph you and fingerprint you and everything else. Lastly, it's also important to understand that as we look to modernize the clerk's office, one of the things that we probably should consider is certain policies that basically would enforce standardization of security practices within the networks that are designed to protect and to serve the public. My special interest in suggesting this is essentially, I live in Kentucky, my children live in Kentucky, my grandchildren live in Kentucky. I would hate to see the integrity of Kentucky county records or documents across Kentucky ever being brought into question. These are things that are important for the longevity of Kentucky as a Commonwealth, and I think it's important enough to testify today in front of you as to why the importance should be considered as we go forward in this. You can modernize the clerk's office without, of course, implementing some of these, but implementing it secures the county clerk's offices for future generations. So I want to thank you for allowing me to speak today, and if you have any questions whatsoever, we're happy to address them at this time.
Any of our members participating in the room or virtually have questions for Mr. Grolla? I don't see any.
Yeah, you sure don't.
Thank you very much.
Thank you so much. Appreciate your time today.
And today's final presentation, I think, Ms. Baxter, are you on virtually with us?
Yes, I am.
All right, we can hear you in the room. And this is a presentation on legal malpractice issues dealing with electronic databases. So if you would just introduce yourself for the record, and then you may proceed with your testimony.
I'm Ruth Baxter. I'm an attorney in Carrollton, Kentucky, and I appreciate the opportunity to be here today. By virtue of my presentation, I want to give you some background. I've practiced law for over 40 years. Over 2/3 of my practice deals with real estate. So I was asked to talk to you about legal malpractice issues relating to the electronic databases that are contained in the county clerk's office. I guess I'm one of the dying breeds who still goes to the county clerk's office to run titles. And in order to make a living, I represent several banks and lending institutions. In addition, for the past 30 years, I've served on the board of directors of Lawyers Mutual Insurance Company. The attorneys on the committee may be familiar with that organization, but we are the Kentucky Bar Association related legal malpractice insurance carrier for attorneys in the Commonwealth. The majority of our insureds are solo and small firm practitioners, many of whom do a lot of real estate work. While I'm not speaking on behalf of the company, I thought it was important that you understand that my background and that I've served on the claims committee of that organization for many years, and real estate malpractice claims against attorneys have been either the first or second largest number of claims with our company. Again, if you have never run a title in the county clerk's office, then you don't know what we did, what we're doing now, and where some of the county clerks have improved. Prior to having computerization of county clerks' records, the documents were literally filed with the clerk and they would be hand indexed, either handwritten or typed indexes. Then we went into a little bit more modernization and had a computerized indexing system, which allowed the clerk to enter the data directly on the computer system for access by the public at computer terminals that are furnished in each of the county clerk's offices. We now have updated scanning systems that allows the clerks to scan documents for both indexing and copying into the system simultaneously. And more recently, the modernization programs have allowed e-filing documents. While it is still relatively new, it is not routinely used. The clerks in our area tell us they get from 2 to 5 e-documents to record on the average each week. We thought that would be increased by virtue of the pandemic, but we've not seen that increase as the clerks anticipated. Right now, if you want to e-file, to understand the process as it is set up, if you want to e-file, you have to contract with an approved vendor. Each county clerk has a list of vendors on their website that are approved. You have to register with that vendor. The vendor requires identity confirmation that you are a certain entity, be it a lawyer, a mortgage company, a bank. The vendor then provides software, and the vendor then files the documents with the county clerk software company. So this varies from county to county as to which software company a clerk is using. The county clerk software company is the company that actually sends the documents to the clerk. The clerk gets to review those and then determine whether to approve or reject them. If they reject them, then there's a reason provided to the e-filer. Notably, the clerk's software program disclaims liabilities for missing pages in the documents and even for authenticity, which is a concern that lawyers have when you're reviewing documents in the clerk's office. The clerks tell me that the typical reasons for rejecting documents is because the e-file documents do not meet all the standards for recording, and they fail to meet those standards by omitting information or not including the complete document. Sometimes we have a mailing address for tax bills not included. People who file from out of state typically don't understand the requisites for Kentucky to have a prepared by statement to be signed instead of typed, or they have not included the correct deed book or page numbers. But there are certain limitations on the clerk's ability to reject the documents. And the clerk always will acknowledge that they don't know anything about the parties or the notaries that are involved. So therefore, fraudulent documents can be difficult to identify. There are some saving grace statutes that you have for an attorney. KRS 382-230 provides that a conveyance is not void if the clerk fails to properly acknowledge it in the process of recording it. KRS 382-270 states that a deed or mortgage that's not acknowledged or approved by law becomes valid if the clerk does in fact record it. 382-297 allows amendments of recorded mortgages so that an attorney can correct typographical errors or other non-substantive provisions if they discover an error after it's recorded. And 382-337 allows an affidavit by the party or the attorney who prepared a deed to correct information such as omitted marital status or notary information that was in the records incorrect. Now, if you look at the risk of using electronic recordings, and I know that this committee is considering allowing the public to use electronic recordings, historically, there's not too much research on legal malpractice claims, but there is quite a bit of research on electronic malpractice claims. The 5 risks of electronic claims through the United States are, first of all, employee error in inputting the information. And you're going to have this potential whether the clerk is accepting e-filing or whether they are filing by hand in the office. But if the employee inserts the wrong names or misspells the names or inserts the wrong recording data, then that's going to contribute to errors. If you have the user of the records who comes to does not understand the process or how to access the system, then obviously you're going to have problems with electronic records. Your previous speakers talked about security breaches such as hacking that can happen. You can also have inaccurate information being placed into the system because when there is an e-filing, there's not the same ability to maybe understand the document. And also you have lack of encryption protocols where documents could be hacked if they do not meet the protocol data that you have for your respective county clerks because they're all a little bit different on their security systems. Now, regardless of the issues or the methodology, I think you have to acknowledge as a committee that no system is going to be able to prevent false information being contained in the documents. No system is going to be able to prevent altering information that's been contained in the documents after they're signed, fraudulent signatures, forged documents or signatures, false notary statements or falsified notary statements, or even fraudulent or deceptive information that are contained in the documents that are filed. And so whether you have hand filed documents, scanned documents, or e-filed, these are the types of problems that we attorneys try to deal with when we're handling the recording and reviewing of documents in the county clerk's office. And ironically, your rural counties, like I practice in, they do a better job because they know people in the community. They know who is or is not a notary by virtue of having those records in their county. And so ironically, some of the smaller counties do a better job in rooting out some potential for fraud or for potential for false documents by virtue of their knowledge of the people in the community. Now, attorney liability in Kentucky, attorneys are not liable for every single mistake in their practice, but when you have a title exam, attorneys are held to a higher degree of a duty. They have to exercise reasonable care in researching the records. They have to act to the best of their knowledge about the information contained in those records, and they have to have a proper degree of diligence in that search in order to understand the issues with the title. Obviously, they have to understand how the computer system works and how the indexing system works at the county court clerk's office. If you wanted to make a negligence claim for attorneys in a title exam, you have to show that the attorney has a duty, that the attorney breached that duty, that as a result of the breach, the person incurred damages. And this is called a suit within a suit because you have to prove, but for the attorney's negligence, the plaintiff would have a good title or would have recovered in the case. Now, when you apply that to attorneys using county clerk records, you have to have an unmarketable title. The attorney did not discover the defect despite using reasonable care, and the client is damaged as a result of the failure to exercise reasonable care. But then we have the but for question. But for the attorney's negligence, would the plaintiff have a clear title to the property? So that would be the question for a jury to answer if the matter could not be resolved otherwise. Now, what are the most common real estate negligence claims against an attorney? The number one that our company has seen is where an attorney fails to make sure all the mortgages or liens are released. And this is the number one issue that we have. The second issue that we've had through the years have been the liens are not perfected on titles to mobile homes or manufactured homes. As the committee has probably learned, that process has changed throughout the years, depending upon whether it's a mobile home or a manufactured home, whether the title's been converted to real estate. And so that has been a problem for attorneys. And also liens against new purchasers that have not been disclosed and take precedent. A few years ago, the Kentucky Supreme Court ruled that if a purchaser had an existing lien against the property, that existing lien could take precedent over certain liens that the purchaser incurred in buying the property. So that has been a problem that attorneys have to check not only they have to check not only the seller of the property, but we now have to check the buyer of the property to make sure there are no existing liens. Attorneys now are able to limit their liability. I know you had a presentation because I went through your previous minutes and presentations from title insurance companies. And similar to title insurance companies, when attorneys issue title opinions, they're addressed to the requesting party and they limit their liability for certain things, certain documents that are not true and authentic, or they limit their liability to properly index records of the county court clerk. They also may limit their liability to the amount of the loan or to the purchase price of the property. But you do see title opinions that restrict or limit an attorney's liability from false information being on the documents, from the documents being fraudulent themselves, from forged signatures, and there are a multitude of exclusions that different attorneys use based upon the practices of their county court clerks. But again, title insurance policies similarly exclude those same risks. So what negligence issues you're asking will be presented by e-filing in the county clerk's office? Well, we discussed this not only among the county clerks, but also among some of the attorneys that do regular title work in the county clerks. And we came to the conclusion that many of the same issues that now exist with false documents or forged signatures or improper notaries, there's really no way to discern whether those documents are authentic, whether they're e-filed, whether they're scanned, or whether they're hand-delivered. We do believe, however, that if you're going to go to public filing, you must have integrity to the documents so that there are safeguards in place. Currently, using the vendors or using other third parties to vet the filers has been fairly successful and has reduced or restricted the amount of issues that county clerks have had with documents. And we as attorneys think provides another screening process, which gives us more ability to rely upon those documents. The other negligence issues that need to be addressed are the training for the county clerk's staff on processes. I talked again, we rely upon our county clerks and deputies, and we have a good working relationship with them. During the pandemic, I don't know that our law office could have functioned without the assistance we got from them. When they were closed, they were still taking literally filed documents through the windows of their offices in order to allow us to continue to do business. But they will tell you that the training that they have on these processes is very minimal. Online training for 20 to 30 minutes, one clerk told me. And at the same time, they have limits on the number of staff members within their offices that are trained to input data, to do e-filing or to do scan filing. We saw this again during the pandemic. If the deputy that was assigned to do the recording was ill, couldn't come to the office, then literally we went through days and sometimes weeks with getting documents recorded because not enough people in the staff had had the training in order to understand how to do that. But at the same time, we need to train users, and attorneys are number one on the list. We need to understand how to access the information and how to understand e-filing. Those lawyers on the committee will know that in order to e-file with the court system, attorneys are required to go through a 4-hour training process and be approved for e-filing. And so some training in that requirement should not be considered unusual by this committee, especially if it's going to allow the general public to now become e-filers on the system. So what ways can you as the legislature help reduce potential attorney negligence claims for e-filed documents? You can make statutory limitations for the liability of the documents accepted for e-filing if they meet the filing requirements. And what we're talking about is creating a presumption that it would be presumed that if the document was e-filed, accepted by the county clerk, and met the county clerk's requirements, there would be a presumption that the documents were authentic. And then it would give us some authority on which to rely upon those documents. It would be a rebuttable presumption, we understand, but still it would help ensure that there is some integrity to the documents. Utilizing third-party vendors to handle the process is also something that can reduce negligence claims. I understand that it's an expense to rely upon a third-party vendor, and I understand that they are sort of excluding their own liability for some of the process. But I think you deter people who are deliberately trying to hack your system or to file fraudulent documents if they have to go through a third party and present credentials as to who they are and why they're e-filing with the county clerk's office. Also, right now, there are really no penalties for filing false documents or providing information on filed documents. And maybe that would get some attention if they understood that they needed to review the documents before they're filed to make sure the information is accurate. Some of the questions you're going to have to address is who's going to retain the original documents? In e-filing right now, the e-filer keeps the original documents. But how is that going to help if a company out of state is keeping a person's original deed? Does the person who had the deed that was e-filed, aren't they entitled to get that deed back? How long do those documents have to be retained? If they're going to be e-filed in the records, does the attorney have to keep them indefinitely? Do they have to keep them 5 years? I know the county clerks don't want them because they give us records back after they scan them. But what are you going to do with the person who e-files? What are they supposed to do with the records? There's also some question about increasing bonding requirements for county clerks. Right now, the bonding requirements in the event that they misfile something or the documents are entered into the computer incorrectly, and there is, say, I had a situation a couple years ago where the clerk released the wrong mortgage. There were multiple mortgages by the same bank on a piece of property, and the clerk either didn't pay close attention, but they released the wrong mortgage. The homeowner was able to sell the property and not pay the first mortgage lien. But the bond that the clerk held at the time was very insignificant as far as the loss that was incurred in the process. So maybe we need to also look at bonding requirements for county clerks. Maybe we need to spend money enhancing the training for the clerk's deputies, as well as provide for online training for users of e-documents so that we can make sure everyone understands the integrity of the system and tries to uphold the system. So I realize that that's quite a bit of information, but I appreciate the opportunity to testify before the committee, and I'm glad to answer any questions that you all may have about potential attorney negligence as you explore this e-filing process. Thank you.
Questions from members of the committee? I do have a couple, Ms. Baxter, myself. Could you give kind of an example of that liens against new purchasers not disclosed? You talked about that a little bit in the Supreme Court ruling, but could you go into a little bit more detail about that specifically?
Sure. Let's say that John Jones was buying a new house and he went to a bank and was getting a mortgage for the property. And before the Supreme Court ruling, you would research the seller's titles. So you would go to the courthouse and look at Sam Smith because he was selling the property to Mr. Jones. If Mr. Jones had a credit card judgment against him and it was filed of record in the courthouse, then that lien could take precedent over the mortgage for the new purchase of the property. So that's the issue.
Okay.
It also applies to court judgments that may or not be related to debts. It also applies to state tax liens that may have been filed of record against the person as well. So this has created a new liability for attorneys.
So it'd be
if they don't check both the buyer and the seller.
Debt judgments, court judgments,
state tax liens, federal tax liens.
Anything else that would fall under that?
I believe that's pretty much the list.
All right. And then this may be a question that goes a little bit more in depth, and the clerks may want to respond to this, but on the areas where e-filing does occur, is there a hard record kept in your files at all? Tabitha or Jason, you all may want to come forward to address that. Just introduce yourself for the record, Tabitha, if you don't care.
I'm Tabitha Clemens, Grant County Clerk. When we record documents electronically, they come into our screen and we can view the document. At that point, if our in my office, it's a preference on the deputy who's recording the document. I have a deputy who, like Ms. Baxter, prefers to have something tangible in her hand. So she may print some of those documents. Another one that I have prefers to look at it on her screens. So they review the documents. At that point, it's scanned into the system. And then the next morning, when we verify our documents, we are still printing deed and mortgage books in my county. So the deed would be printed at that point out of the scanned system. The electronic file, once the book and page number is placed on the e-file document, that is then sent back through the vendor, either EPN, CSC, or Simplifile, back to the person who created the document electronically. That's sent back. So there's not the paper document that's dropped off to our office, by local attorneys still, they get those documents returned. The electronic filing documents get those returned electronically. Does that help?
But you're still keeping an actual paper record in a mortgage or deed book.
Correct.
As well. Is that across the board the case? Is that addressed in statute or?
My understanding, deeds are addressed in statute. They're still, to my knowledge, all of the counties are still keeping deed books printed. Some counties, due to space and storage, have been able to work with the retention schedule to be able to hold the electronic copies of mortgages, but to not print some mortgages. We're still printing both in my county. We don't have a space issue at this point, but some counties are very restricted on space, as you can imagine.
Jason Denny here from Anderson County. 6 or 7 years ago, we had direction from KDLA that we could, at that time, as long as we microfilmed in addition to the image, either every 6 months or once a year, that we could discontinue the printing of mortgage books. So I'm not going to say every county. We still print on legal paper instead of the mortgage paper and put it in a binder as a backup copy until we microfilm, but I can't speak to every clerk on that. But KDLA did give us direction on that 6 or 7 years ago.
This is Debbie Donnelly from Hardin County, excuse me, and we still print ours on acid-free paper, and instead of putting them in binders, we have those in acid-free boxes.
Any other questions from members of the committee on this topic? Nothing online either.
Did we get a CLE credit for the presentation?
Have to take that up at the bar, I think.
Okay.
I think that is the end of our printed agenda. Tabitha, if you all don't mind to hang around for just a second, just if there's anything else that you all would like to add to the discussion as kind of a final follow-up to everything. Today was meant as kind of a cleanup meeting. Ms. Baxter, they couldn't present at some earlier meetings, same with Data Records Management Services. And then Jennifer was coming to present on that issue with KDLA, just to kind of set the stage that you all are collecting all of those today, where at one point in time when the statute was created, that was not the case. And so want to give you all the quick opportunity, if there's anything else that you all would like to share that at this time as well.
Only a couple of things that I saw in some presentations. I can't speak for every clerk, but I know most of our clerks are very diligent in their training of their deputies that take in these recorded documents on how to do it properly, what to look through. We have recording manuals that we look at daily to be sure that they are a recordable document. So I do believe that most of our clerks are already doing this and have backup people in place to record these documents. One thing on the legal process fees, it basically implied that we turn that money over immediately. It is a quarterly report that is sent in, so we do that on a quarterly basis.
I just want to take the opportunity to thank the committee for your commitment to this endeavor and for being very open with the Clerks Association and allowing our input at every turn. We're very grateful for the opportunity. And I also want to say that I've learned something from every committee meeting that we've attended. So it's been great to have vendors presenting, folks from the bar, from all aspects of how this will affect our offices and all of those customers who we interact with on a regular basis. So I commend the chairman for their due diligence in this process and look forward to working together as the session moves forward. Thank you.
I would say it's very refreshing that this is a collaborative group working together to change how we do things.
And I want to say that as well. Working together is what it's all about, and that's how you work issues out. And so thank you all so much.
Well, and I want to thank the clerks, the business community, the vendors, and everybody else who has worked on throughout the process of the last several months. I think we have gotten good information. I think we have had a relatively collaborative effort amongst members of the committee and the business community and the clerks to try to address a problem that we've known was a problem for a long time, and I think that the pandemic really brought heightened attention to, frankly. I think we have some good ideas moving forward that we've gotten fairly broad-based consensus on to move forward and achieve the goals that pretty much everybody that has participated wants to achieve. And so I appreciate everybody working in such a cooperative manner through this process, and certainly you all for bringing the expertise of your office and sharing with us at every opportunity. So thank you all very much. As we conclude, does any other member of the committee have anything they would like to add or ask a question on before we finish up today?
Mr. Chairman?
Try to put them up on
Senator Mills.
Facebook.
Yes, sir. Just wanted to ask a question. Is there going to be a report compiled and possible legislation listed, or how are we reporting back to LRC from this task force?
Randall, I think there will be what is the terminology you used?
Research memo.
There will be a research memorandum that will be printed. They are working on a draft of that. Co-chair Hal and I will have to sign off on that before it is published. There may very well also be some legislation coming as we move into the session. I don't think there will be specific recommendations for legislation in the research memo. It will be more of a compilation of the things that we have discussed in these meetings.
Very good. Thank you.
Representative Flannery.
Very briefly, I would like to echo the comments from Chairman Meredith. This has been a very interesting task force to serve on, and I've enjoyed it. I've learned a lot, and I do appreciate all the members of the business community and the county clerks for your efforts, and hopefully this will produce some good changes. Thank you.
And I also want to commend my co-chair, Senator Howell, for his work throughout this process as well. He couldn't be with us today, but he wanted to share his regrets for not being able to be here. And again, I want to thank him for his work over the last several months as well. Seeing no other business before this committee, I would move for adjournment. Do I hear that motion?
Second.
You got a
Motion.
second